Thank you so much for joining us. We are now entering day three of the Lindsay Clancy trial, and we are debriefing you after attending that court session. We are going to bring in our reporter, our Nicole Moeder. She has been in court for each of these 3 days of jury selection so far. And just to recap, Lindsay Clancy is a Duxbury, Massachusetts mother who is facing 3 counts of murder for her 3 young children. This is going to be a highly watched case. And again, we're on day three of this jury selection. So, Nicole, just kind of give us an overview of your experience thus far in court today.
Yeah, it was a very interesting day, a very interesting end to the day. There is one juror that is left to be seated in this trial. They seated 4 jurors this morning, and then after lunch, they dismissed everybody that came through for some reason or another. And I actually was told that they ran out of people. So jury selection will continue tomorrow because the judge is adamant that they will seat 18 jurors in this trial. And I'll tell you why. Yesterday, there was a man who had been seated on the first day in seat number 2. He came back into court and basically told the judge that he heard about the case and he thought about it, and he doesn't think that he's capable of sitting on the trial. And I think that, or sitting on the jury, and I think that the judge is expecting for more people to potentially drop out, become overwhelmed by the testimony. This case is heavy. Lindsay Clancy is accused of strangling and killing her 3 children and then jumping out of a second-story window in an attempt to kill herself. And the defense is actually not denying that this happened. The argument that they're making is that Lindsay Clancy was over-medicated and suffering from severe postpartum depression, and that is the reason that she committed those acts, and so therefore she is not criminally responsible because she was not in her right mind. The evidence will be incredibly gruesome. We're talking about the death of children, and so the judge wants to make sure that they have as many people as possible. They have a full 18 jurors, that's 12 jurors and 6 alternates. So jury selection will continue into tomorrow. It was another very emotional day in court today. Multiple of those potential jurors, they were crying. They were overcome by emotion. Oh, those jurors were, of course, dismissed. But I think it's just a precursor to what we are expecting to see in the future, in the coming days as this trial begins to unfold. I was told by Lindsay Clancy's attorney that they are hoping to finish up jury selection tomorrow to get that one last juror, to get them to 18, seat that juror. Then they'll do some pretrial motions in the afternoon. And then they are hoping that they will be able to start opening arguments on Friday. And then I'm also told that we expect the first witness to be Lindsay's ex-husband, Patrick Clancy. So that will be some very, very, very emotional testimony right off the bat.
I think the duration of this trial, slated for 6 to 8 weeks, really speaks to the emotional weight that you're describing as they move through this process of jury selection. So, with that in mind, can you give us an idea of how many jurors we've gone through on each of these respective days?
Yeah. So on the first day, we were told that they brought in about 120 jurors. Yesterday, the other reporters and I, we counted about 90, between 90 and 100. Today, we counted between 90 and 100. I actually went back and looked at some of the numbers to compare across the 3 days earlier today during our lunch break. On day one, the judge every day asks these group questions to try to determine if they have any personal biases, if there's any reason that they would not be able to sit for the full duration of the trial, if they know anybody involved, if they know anyone on the witness list. The potential jurors, they raise their card with their juror number on it, and then those cards get read out in open court. On day one, of the 100-ish, a little more than 100 person jury pool, about 31 of them raised their card for at least one of those questions to answer. Yes, I am not able to serve for the full duration. I do have a bias. I do know someone, et cetera, et cetera. Yesterday, I want to say 20 or 30 raise their cards to say, yes, I do have a bias, I can't serve. 51 today of the about 90 people that we had in that courtroom in the beginning raised their cards. So that made the jury pool for today very, very limited. So they are flying through these jurors, and a lot of them are getting dismissed. And I should say they're getting dismissed for a whole host of reasons. Some of them say, I can't be off of work. I'm taking care of my kids. I'm a stay-at-home mom. I don't have childcare. I live paycheck to paycheck. I'm a student. A lot of these people are students. They come in, they say, I'm supposed to go back to school in the middle of August, at the end of August. And the judge will say, well, I can't, promise you that this trial is going to be over, so I'm going to dismiss you. And then a lot of them say, I've heard about this case and I just don't think that I can be unbiased. I've formed an opinion and I don't think that I can listen to the evidence only presented in court and render or come up with an impartial decision. So that's the reason that you're, seeing so many of these jurors come through the doors. Again, not just the emotional testimony, but as you mentioned, it is the length of the trial. 6 to 8 weeks is a long time to be sitting in a courtroom, either for work reasons. Some people have physical or medical issues where they can't sit in court for that long, for that duration of time. So it's very challenging to find people who are unbiased, who don't know anybody in the community, and who also have the availability and won't suffer a hardship by being in court for 6 to 8 weeks.
And just as a comparative analysis, I do believe that when Karen Reed, another high profile Massachusetts case, when Karen Reed was on trial, the jury selection process there, if I recall correctly, was about 10 days, and they went through upwards of 300 jurors. So we're already seeing that, based on what you're saying, Nicole, over the course of 3 days, 90 to 100 jurors being screened each day. And then notably today, with approximately half of the jurors bowing out. What do you think that says to the range of the questions that they are asking of these jurors in the screening process?
I've looked at the proposed the proposed juror questionnaires from both sides. A lot of them are asking, do you know someone that has suffered from postpartum depression? Do you have exposure to someone with mental health issues? Again, do you have a job that you can't be out of for that long? I think the difference, since you mentioned Karen Reed, between that trial and this one, both of them are very of public interest. They're highly watched. There's a lot of people that are going to be paying attention. This trial is much more gruesome than Karen Reed's trial. Yes, both of them do involve death and murder, but we're talking about the murder of children in this case, ages 3, 5, and 8 months old, that died by strangulation. We do expect that we will hear the 911 call that was put in on the day of that incident, and we are expecting that we will see autopsy photos, that those will be introduced as evidence. And I have heard some of these jurors say, I have young kids and I just don't think that I can be a part of this. That is or my wife had postpartum depression. My sister had postpartum depression, and I don't think that I can be a part of this and be unbiased. I don't think that I'm emotionally and mentally capable of it. So those are some of the questions that we've been seeing, again, logistically, but also mentally and emotionally, that this case is going to ask of the jurors. And I think the judge and both of the attorneys, or all three of the attorneys, are really sensitive to that.
And I think that what we will hear repeatedly throughout the course of this trial is this notion of criminal responsibility, whether the postpartum defense renders Clancy basically unresponsible for the actions that she took that she allegedly took on that gruesome situation. So I want to talk a little bit about what we have heard from the judge and from the attorneys. Have we heard any guidance or any directives coming from the judge in interacting with the jurors, potential jurors?
Not from what we can hear. It's kind of unique in my experience in covering trials. We cannot hear any of the voir dire questioning that goes back and forth. It's all done up at the bench, and there's this static sound that plays in the courtroom to try to keep those conversations more quiet. So what we hear as reporters in the courtroom is what the judge states in the morning when he greets all of the jurors and gives them instructions. He, of course, instructs them on the Constitution constitutional responsibilities, the constitutional rules, I should say, that apply to every trial. But he does address that issue of criminal responsibility, and he describes it as a legal term that the Massachusetts, the Commonwealth, has the burden of proving that Lindsay Clancy was cognizant, that she knew what she was doing, and that this was premeditated. And he is very, very clear with those jurors, and he asks them multiple times, both in the group setting when he asks them to raise their cards, but also when they're up at the bench. We can overhear him asking them again to ensure that they are capable of differentiating. Yes, maybe she did this, but the Massachusetts, the Commonwealth, has the responsibility to prove that this was intentional, premeditated, and planned. And planned is a key word here, because her argument is that, or the defense's argument, I should say, is that this was a moment that she could not control herself, and it wasn't planned. And in those 45 minutes when she was home on her own, that is when she, had this break and committed this act. And so the Commonwealth has to prove that she had planned this for longer than that period of time. That is a high burden of proof, and that is what is going to be expected of them in the duration of this trial.
Let's talk about the jurors. You've been there as each of these potential jurors has transitioned to actual impanelment. Tell me a little bit about the breakdown of the jurors thus far. What do we know about them?
So I'm going to check my notes to make sure that I'm getting this right. We know that there are 10 women and 7 men seated right now. Most of them are white. 2 of them right now are black, if I'm looking at a glance, if I'm looking at this correctly. They range in ages. There were some who looked as young as, in their late 20s. And then there are some who are older and looked like they were in their 70s. I really wish that we could hear the questioning better. Myself and the other reporters in the room are listening really hard to try to get any piece of information that we can. All of the jurors, of course, that are seated do seem unbiased. I will note that the longer the questioning goes, the more likely that that person is going to be seated. So the judge starts with the questioning. Obviously, he goes back and forth, and then he asks the attorneys and to ask their follow-up questions. And for the most part, both sets of attorneys, the defense and the prosecution, are asking questions, and those are the jurors who everybody feels confident can sit on the jury and can be impartial. And those are the jurors that we do ultimately end up seeing seated.
Talk to us a little bit about the interactions that you have had with the attorneys, the conversations that you have shared with them in the course of this jury selection.
Yeah, I have spoken a lot with Clancy's defense attorney. He comes out in and out of court. He, speaks with us when he can, if they're in recess, if they're in a break. He is very chatty with us. He has told me that this process is very challenging for Clancy herself. She is actually seated in the witness box during the voir dire process. So the potential jurors, are sitting in front of her. So she is watching some of them be incredibly emotional. Some of them cry. Attorneys have had to hand jurors tissues because they're so distraught at the thought of this case, at the actions that she committed. And we also hear these jurors say, I have a bias, I have an opinion, and I'm not changing it. And she has to be witness to that. So I'm told by her attorney that this is very challenging. She shakes. She's very scared. She trembles. She broke out in hives yesterday because of how, emotionally traumatic this is for her. And he says that he's not a doctor, and the only thing that he can really say to her is that they're going to get through this. I haven't had as many conversations with the Commonwealth. They are a little more tight-lipped. They usually direct us to their office and say that their office will put out a statement if we have any questions. And, as I said, we really don't hear that much because a lot of the pretrial motions, a lot of the conversations are either happening up at the bench or they're happening behind closed doors. So as the press, we're not exposed to that in a way that we might be in a different setting or in a different trial.
I'm glad that you brought up some of the pretrial motions, because while those are mostly done behind closed doors, there is some element of that that's public.
Yes, so we can see the motions as they're filed. So, for example, one of the motions that was filed today was On behalf of the defense, they are asking that the press not have access to the 911 calls and some of the autopsy photos, specifically of the children. We are told, I am told by Clancy's lawyer, that that is on behalf of Patrick, Lindsay's ex-husband, because he has privacy concerns about his children. And her attorney says that he does not feel that this will have an impact on her case. So it's my understanding that this motion is asking the judge to allow those exhibits to be brought forward in court. The jury will have access to them, but then the press will not. That is my understanding. I believe that that motion will be heard tomorrow afternoon. They are again hoping that to get that final juror seated in the morning with a new jury pool, and then they will hear those pretrial motions in the afternoon. Like I said, those all happen behind closed doors. So I have asked both sets of attorneys about it. And what I just laid out is basically all of the information I have on that.
All right, so Nicole, you've been very diligent in covering all of this and sitting in the courtroom, taking those notes, sharing all of the information with us in these daily debriefs. Again, day 3, we're working on getting a full empanelment of a total of 18 jurors, trying to have 12 official jurors and then 6 alternates. We've already had one of those jurors come forward after being seated and say, hey, I don't know if I can actually do this. We're still waiting on another juror that is expected to be seated during the selection process that will happen tomorrow morning, and then potentially looking ahead to opening statements. So anything else that we know to expect from Judge Sullivan or either pair of attorneys at this point?
Not really. I think everybody is very focused on getting this jury set. They are obviously being very strict in the courthouse because they want to make sure that they have a clean trial. Everybody is trying to avoid a mistrial. They are very strict with when the press can go in, when we can go out. The jurors, we are not allowed to get in their way. We have to stand completely out of their way. They have to all be seated in the courtroom before we can go in. When they leave, we leave first and we stand off to the side. So there's really not much more that I can report right now from what we can expect, aside from the fact that they're hoping to have opening arguments on Monday, and that we expect that the first witness will be Patrick Clancy. But aside from that, and we do expect that the 911 call will be played early in the trial. That is what I was told. So we should expect that. I believe that will be played during Patrick Clancy's testimony. But other than that, I think the rest will become clear once we have a jury, once everyone is seated, and when the jurors get more information, the press will get more information as well. That's my understanding.
Much left to be seen. Your reporting has been extensive thus far, and we certainly appreciate you chatting with us about this each day after court, and we look forward to what you have to say on our debrief day 4. Thank you again.